afternoon, everyone, and welcome to the SIAC-CIArb Debate. For those who are here with us at Maxwell Chambers, thank you for joining us in person for this event. A very warm welcome as well to those who are joining us online from Singapore and all around the world. My name is Sue Ann, SIAC's Manager Legal, Strategy and Development, and I'm pleased to be your MC today. I would now like to invite Mr. Kevin Nash, Registrar of SIAC, to deliver the opening address. Kevin, please.
Thank you, everyone. Good evening. I brought this up, the CIArb advocacy tips. This is going to help me through the welcome address. If you haven't read it, there's a copy on everyone's seat. It is actually a really good manual. It is great to be back in person. It is great to have so many people online. The SIAC-CIArb debate has become one of the most important events on the arbitration calendar. For my part, as a fan of arbitration and as someone who works at an administering institution, I am looking forward to the motion of that this House believes that parties should not be allowed to appoint their own experts, and tribunal-appointed experts are the way to go. I think I may have my views on what side of the table I would like to be on for this. So there is some work for our debaters. Let me give you a bit of background and a view from the institution. So given SIAC's increasing caseload and the fact that we're getting higher value disputes, we are getting an increased use of experts in SIAC disputes. We have a quantum of more than USD 30 billion in the last 5 years, parties from more than 100 jurisdictions. And to put it in declarative terms, if it is high value, complex, there will almost certainly be experts involved. Arbitrations can be bifurcated, trifurcated with separate stages on jurisdiction, liability, and quantum. There might be quantity surveyors, engineers, forensic accountants, economists, and many other sector specialists. There can also be tiered or split clauses followed by arbitration. So the traditional role is for the party-appointed experts to draft an expert report for a party and then testify at a hearing. Parties can also jointly agree to appoint a single expert, and there is also, from time to time, and on one side of this table, tribunal-appointed experts as an alternative or in addition to party-appointed experts. To help us navigate, we have some guidance under the SIAC rules on tribunal-appointed experts, and then very helpful soft law in the form of the CIArb protocol and the use of party-appointed expert witnesses, which is often adopted in SIAC arbitrations. Like many arbitration laws, many of the institutional rules are silent on the responsibilities of party-appointed experts, and typically will address the role of tribunal-appointed experts. So without trying to step on any of the points in this debate, there are some of those thorny issues that we have for tribunal-appointed experts, and that there's a natural concern that the tribunal may delegate its decision-making power, the idea that there could be a second or fourth arbitrator, less control in the presentation of evidence. The process itself of a tribunal appointing an expert can be time-consuming, and then that tribunal-appointed expert could have a tendency to promote its own position rather than the position in the competing positions in the field or the positions of the party-appointed experts. We know with party-appointed experts, the idea of a hired gun, whether the experts will take a different approach to answering the same question or potentially disagree on the question itself. Idea of financial benefit from repeat appointments. Do we need an orange list for experts? These are all the issues that the debaters will be discussing in much more detail and with much more nuance than me. So against this backdrop and in the potential shadow of Article 5.1 and 5.2 of the New York Convention, the stakes are high and the hot tub is warm. I leave this to the House and look forward to the debate. Thank you, everyone.
Thank you, Kevin. We will now begin the debate. Today's debate is on the motion, this House believes that parties should not be allowed to appoint their own experts, and tribunal-appointed experts are the way to go. May I please invite the speakers to the stage. Arguing for the motion are Mr. Matthew Gearing, KC, Barrister of Fountain Court Chambers, and Ms. Chia Shi Jin, member of Young Members Group CIArb Singapore Branch and Associate of Hogan Lovells. Arguing against the motion are Mr. James Nicholson, Head of Asia Economic and Financial Consulting of FTI Consulting, and Mr. Samuel Leong, member of YSIC Committee, and Senior Associate of Norton Ross Fulbright Asia LLP. This debate will be moderated by Ms. Sapna Jangiani KC, Chair of CIArb Singapore Branch and International Legal Counsel of Attorney General's Chambers, Singapore. The judges for this debate are Ms. Marina Chin SC, Joint Managing Partner of Tan Kok Chuan Partnership, Mr. Chong Yi Leong, Deputy Chairman of SIAC's Board of Directors and Partner of Allen and Gladhill LLP. Last but not least, Mr. Tan Chuan Tai, SC, Vice Chair of CIArb Singapore Branch and Partner of Raja and Tan, Singapore. I will now pass the time to Sapna. Thank you.
Well, firstly, a very warm welcome to all of you. It's a great pleasure for CIArb Singapore to collaborate once again with SIAC on this debate. This is our 6th joint debate, and it has become quite a tradition on the arbitration calendar in Singapore, as mentioned by Kevin. Long may that tradition continue. Thank you to our sponsors, Fountain Court and FTI Consulting, without whom we could not put on this event. They've supported this debate for several years, and we are very appreciative, and long may that tradition continue as well. Now, a quick run through of the structure of the debate today. What we'll start off with is a quick poll to find out where our audience stands on the motion before we hear from our debaters. Then we'll hear from each speaker for 10 minutes. Then we'll move to questions from our judges and questions from the floor. Heckling is not only allowed, it is positively encouraged, as are difficult questions. We'll then move to one speaker from each side for rebuttal arguments. And then we'll go back to our audience polls to see where our audience stands after hearing from our debaters. And then we will hand over to the judges who will give their views on the motion after hearing from the debaters, as well as some comments. Now, although these proceedings are very serious indeed, I thought it might be nice to hear one fun fact about each of our debaters before we kick off. Now, I've asked panels before for fun facts, and in professional services, I have to be honest, we often have to dig really deep to find that fun fact. But I'm happy to report that our debaters today had no difficulty whatsoever in finding a fun fact to share. So if we start with the team for the motion, Matthew Gearing's fun fact is that at the tender age of 16 in the 1980s, he both participated in and won a British quiz show, which I have to say was one of my favourites in the 80s, called Blockbusters. Now, this will have special significance for the British members of our audience that may well have been fans of that quiz show in the 1980s themselves. As for his sparring partner, Shijin Cha, her fun fact is that her job interview skill is her ability to rap super bass by the inimitable popular rap star Nicki Minaj. And apparently this has been a successful career approach for her, which has landed her many jobs. She was very quick to point out that it in fact didn't land her current job as an associate at Hogan Lovells. And I think we'll have to ask Kent Phillips later why that's not in her job description. James Nicholson's fun fact is that in early 1993, his actions led to a flash crash on the London Stock Exchange. But of course, please don't let that put you off instructing him as an expert. I'm sure there's a very good explanation which he can share with you later. And last but not least, the fun credentials of his debating partner, Samuel Long, include the fact that he custom ordered a 5-meter tall bouncy castle for the after party at his wedding. Now, for those of you watching virtually, you may not appreciate just how very tall Samuel is. And all I can say is that if I had been at that after party, I'm not sure that that's an experience I would have survived. And now to the very serious business of the day. The motion before us, which you have on your screens, is this House believes that parties should not be allowed to appoint their own experts, and tribunal appointed experts are the way to go. So I've run through what the structure of the debate is. Without further ado, I'd like to invite the first speaker for the proposition, which I understand is Matt, to present to us for 10 minutes. Over to you, Matt.
Thank you, Sapna. Good afternoon, evening, morning, wherever you all are. It's a great pleasure to be back in Maxwell after some 2 and a bit years in a hearing room that's been the site for me of a number of interesting and memorable hearings. As regards our motion, this House believes that parties should not be allowed to appoint their own experts, and tribunal appointed experts are the way to go. Now, Shijin and I have 20 minutes between us to commend the merits of what we see as an utterly obvious proposition to you. Now, let's be clear what this is not about. This is not about the status quo, because tribunal appointed experts are little used at the moment. This is about what we should be moving towards. This is about what we should be doing to improve the arbitral process, which is, of course, a process which is dear to all of our hearts. One which, if one perhaps puts it slightly too broadly, we all have some shared co-ownership in. Now, the machinery for tribunal appointed experts has been there for a long, long time, back at least to the early mid-90s, and then appears in various statutes from 1995, 1996 onwards around the world. Why is, however, it so little used? Well, the reason we would say it is so little used at the moment and it needs to be further encouraged is because to use it and to use it properly, tribunals need to be engaged early. They need to be engaged positively and proactively. They need to take a matter by the scruff of its neck at the very early stages. I have been doing the rounds of arbitration conferences for probably 25 years. Almost every arbitration conference I've been to since essentially I was in short trousers, people complain about, often rightly, about a lack of early engagement by arbitrators in the issues. If an arbitrator or a tribunal together engage early together in the issues, then you are, or they are, much more likely to grasp the nettle and to instruct their own expert, to take the matter away from the direct control of the parties in the first instance. Instead, what normally happens, as most of us I think know, is that a party either says, with a bit of a wave of the hand, metaphorical or otherwise, at the case management hearing, we intend to adduce expert evidence from a forensic expert, from a technical expert on this point, but sometimes parties don't even want to be drawn on that. They like to keep their powder dry, they like to wait, and it all comes as a tremendous surprise when you get the 700-page brief together with the, by then, 3 expert reports. Kent is smiling. It's an incredibly well-known, it's an almost daily, or it's a case, it's an occurrence that bedevils most cases. Now, before we plunge a little bit further into this proposition, let us all be sure we know exactly what an expert is. And it follows from that if we know what an expert is, we should know what an expert is not, or what an expert should not be. So where did I start? Well, I'm not afraid to say I started where I often start on these things, in the pages of PLC. Has been my reliable friend for over 20 years. And right at the start of the Guide to Expert Evidence in PLC, it says this. It says, expert evidence is used to assist the court when the case before it involves matters on which it does not have the requisite technical or specialist knowledge. Now, that applies to court proceedings, but the same definition most definitely applies or should apply to arbitration proceedings. But what is an expert not, or what should an expert not be? Firstly, an expert should not be someone who opines on the meaning of a contested provision in a contract. Experts very often do that. There's no place for that to happen in arbitration proceedings, at least in my opinion. Secondly, an expert should not reach factual conclusions in favor of the instructing party, or, as they often do, assume facts in the favor of their particular client without either properly or completely or honestly considering the relevant counterfactuals. Thirdly, they should not become a de facto member of the client team, one of the troupe, if you like, one of the essentially arguing party. And fourthly, they should not have other interests, other mandates for that client, or I must say for that law firm, that risk giving rise to an objective question regarding impartiality. All pretty obvious no's, I would say. If the tribunal is grasping the nettle, as I say, and instructing the experts, you're much less likely to find that you fall into one or more of those or common pitfalls. Now, the problem, of course, we are addressing is not new. It's the issue has been around for some time. All the way back to the 90s, Lord Wolfe, who wrote a seminal report on civil justice reform in the UK, and it's been cited all over the world, said in early 1996, it was a basic contention of my interim report, and remains the case in this report, that two of the major generators of unnecessary cost in civil litigation were uncontrolled discovery, not dealing with that today, and expert evidence. Of all the people I've spoken to, no one has seriously challenged that contention. So that was back essentially in the mid-90s. Lord Wolfe then goes on to bemoan a large litigation support industry generating, he says, a multi-million pound fee income. Well, of course, multi-million pound these days would be wishful thinking, more like multi-billion pound, although I say that without in any way commenting on the size of James's fees. Next, we move, if one wants to appreciate the history of this issue, and perhaps my final point, to an excellent article which reviews the land, an article by Matthew Swinehart in the 2017 Michigan Journal of International Law, a really excellent review of the history of expert evidence in the context of international arbitration. And the most salient point that Mr. Swinehart makes is that we were on the right track, but we have veered off the right track. And the article contains an excellent review how right almost from the Alabama Claims Tribunal cases, and those of you who listened to the late Johnny Vida speak far more eloquently than I could ever do would know that no speech from Johnny Vida was complete without a mention of the Alabama Claims Tribunal case. That in those cases, expert evidence was limited, one rarely came across it. And then international arbitration sort of moved to a separate or to a next level between the wars. And in the Franco-German tribunals, which were established around 1920, 1922, 1923, tribunals started to make greater use of expert evidence, but did so, generally speaking, under their own direct instruction. And I spent a little bit of time this morning looking at the illuminating decision in a case called Burke and the Republic of Germany, where the Franco-German tribunal, of its own motion, almost sua sponte, it appears, appointed an expert to value a specific make and model of car. So a 1922 direct appointment of a quantum expert. extremely straightforward. So they were on the right track in the 1920s, but as I say, they have veered away from it now. There's much more that I can say, but Shijin will put it more eloquently than me. I think first of all, we're to hear from James in reply.
Thank you so much, Matt. Those of you who are really paying attention will have noticed, and in my excitement to hear from the debaters, I actually omitted to conduct the audience poll. Out of fairness to both sides, I'm going to suggest that we listen to James first, and then we will conduct the audience poll. So stay tuned. Over to you, James.
Thank you, Sapna. Thank you, Matthew. Good afternoon, ladies and gentlemen in the room and watching on video. Is this echo annoying? Shall I just turn it off? No. Okay. Shall I put it further off? Maybe you turn yours off.
Yeah.
If you turn yours off. Yeah, but that's.
No, why don't you swap?
Okay. Is that better? Yes. Okay. So, ladies and gentlemen, accustomed as I am to speaking before rooms full of disputes lawyers, experts, and others engaged in dispute resolution, I approached this afternoon with some trepidation. Normally, when I'm in Maxwell Chambers and being engaging with highly trained lawyers, I'm playing on an uneven playing field. Different strengths of the cross-examiner and me are evident. We each have our tools of the trade, and it's a game I understand. Perhaps what the analogy might be lions versus gladiators in the Colosseum. But now I'm dragged blinking into the Colosseum to do battle with champion gladiators, myself wearing perhaps the armor of the gladiator, but with the power, skill, and grace, Mr. Bean. Those of you who've seen the film Life of Brian may remember the scene. And here to do battle with international law's finest. So my adversaries, our adversaries, students of law, dark arts of advocacy. Yeah. Students of law and the dark arts of advocacy, since at least they filled out their university application forms. I checked your CV. Matt, an advocate and debater so accomplished, he's a champion of the King of England, and Shijin, one of the rising stars in Singapore. Ladies and gentlemen, I was afraid of being mauled by the opponents, and afraid, worse, of letting down my teammate, Samuel, one of international law's finest, who deserves better. So how can we even up this inequality of arms? How can we balance out Russell Crowe versus Mr. Bean, Simba versus Garfield, and perhaps even Bacchus? That power, ladies and gentlemen, lies with us. You all here, you watching on video, Samuel and me, not those two. You arbitrators, present and future, you can blunt the sword, defang the lion by listening to the substance of the arguments that Samuel and I will put before you, and by disregarding the advocacy and trickery of the trained advocates opposite. And when you do, you will find that I will do, as I always do, which is to lay before you simply and humbly the unadorned truth of the matter, which is that this motion must fail. Matt raised some interesting points in his speech. I think, and I hope I'm not doing him an injustice, there was one main point, which is that if the proposition succeeds, if tribunal-appointed experts become the norm, then that will fix the lack of early engagement by tribunals. And that to me sounds like using an egg whisk to crack a nut. Perhaps the nut needs cracking, but it's certainly the wrong tool. There are other tools to do this job. Institutions, perhaps, can intervene through their rules, through their appointments, through their informal guidance. The parties as well have significant control over arbitration, again, through their appointments of arbitrators and through other softer means. We hear a lot about party control and the flexibility of arbitration. And if this is a problem, if the problems Matt spoke about are real problems, they don't need to be solved by such a dramatic intervention. Because, ladies and gentlemen, such an intervention would give rise to three big problems, which I will talk about, and two, which Samuel will talk about. The first big problem relates to cost. So cost savings are often advanced as a major benefit of tribunal-appointed experts. But what is the reality of the appointment of a tribunal-appointed expert? The idea is that a single expert will neutrally and dispassionately resolve the issues put before him or her. Their scope may be wider than that of a party-appointed expert because they may be addressing both sides' cases and the cases may not fully overlap. But the thinking is there's only one expert, so there must be a cost saving, right? But if I've learned one thing in being involved in arbitration for nearly 20 years now, it's the primacy, or the importance, I should say, of party control. Parties want control and counsel definitely want control. And tribunal-appointed experts, in my experience, looks to parties and counsel like a big loss of control. So how do parties react in that situation? Of course, what they do is they appoint their own expert. That expert may not be visible to the tribunal directly, at least, but they are there. And they're playing much the same role as they would if they were acting as expert witnesses. And so instead of two experts becoming one, as is hoped by the proposers, two experts becomes three. And it's worse. All three experts now have a wider scope than either party appointed expert would have been, because all three have to cover the full terrain of both parties' issues. That, I suggest, leads to a significant cost increase through tribunal-appointed experts. I've looked back over the many cases I've been involved in, and I must admit, I've never, in the cases that I do, valuation-oriented expert witness work is what I do. I've never seen a tribunal-appointed expert in place from the start of the dispute. That in itself may tell us something about their efficacy. I have seen several cases where a neutral expert was appointed later in a dispute. And in every case, that expert has been extensively shadowed by experts on either side, in line with the point I was making a moment ago. There's lots of analysis and discussion. Sections of the legal submissions may even be drafted by the experts. So I think we can conclude, firstly, that tribunal-appointed experts increase costs, not decrease them. My second point is quick, and it's devastating. It's so devastating that Matt asked me not to use it. And I'm a man of my word. I gave him my word that I would not use it. So I'm going to hide this point for eternity. I'm going to lock it in a miniature hot tub. I'm going to tie it down with the ceremonial chains of the president of the Chartered Institute of Arbitration of Arbitrators, Singapore. Still waiting to see them.
Sorry, I left them at home today, yes.
I'm going to weight them down with the rotting carcass of the proposer's case. I'm going to take them in the ocean and dump them in 830 meters of water in oil exploration block KCL 2015, never to be mentioned again. So nothing more about this devastating point. The third point is another point close to valuer's hearts, which relates to costs. Which relates to competition. The other point was costs. I ask you, ladies and gentlemen, did Tai Tzu-Ying become women's badminton world #1 for 213 weeks by hitting a shuttlecock against a wall by herself? Did Thierry Henry become the Premier League's greatest striker, playing keepy-uppy in his garden? Did Serena Williams become the greatest of all time, playing with a ball machine? No, no, and no. Then why would we expect a tribunal-appointed expert to make a sufficient survey of the evidence, to understand the nuances of the expert issues of the case, to push herself and her team to investigate new conceptual points in unfamiliar situations, in general to get off her laurels and do the job to the best of her abilities, absent the energizing anticipation of critical review by a worthy opponent? The answer, of course, is that we would not expect a tribunal-appointed expert to do that. There is nothing, and I can speak from experience, like the prospect of someone else legitimately making you look bad, to focus the mind and energize the brain to do a thoughtful and thorough job. And a tribunal-appointed expert does not face that fear. You may object that the parties in the tribunal exercise that pressure, but the argument is self-defeating. For the tribunal, it's not their expertise. That's why they appointed an expert in the first place. And for the parties, they can only pressure test if they hire their own experts. And we're back to square one, my point about costs. So in summary, firstly, you can trust me because I'm an expert, not a hired gun. And you can trust us because some of that has rubbed off onto Samuel. Preparations of today. Secondly, tribunal appointed expert means 3 experts, not 1, adding delay, driving up cost. Thirdly, mass, devastating fear, never to be mentioned. Fourthly, our party appointed experts mean competition, which raises the standard of both experts and exposes those who are not up to it. For all these reasons, the motion, ladies and gentlemen, must fail.
Thank you very much, James. Thanks to both Matt and James for locking horns on the issues. We will pause now to do the audience poll. I need you to take yourselves back in time 20 minutes ago to how you felt before you heard from our debaters. Some of you in the audience have voted already, and I understand the instructions as to how to vote are on the screen now. So I'm just going to give you a minute or so to vote, and that includes our online audience as well. No.
James, it's slowly going up.
Or you could have some hired guns in the audience to vote for you. Okay, I think it's more or less settled down. So a bit of work to do on this side of the house to shift the audience. And with that in mind, I turn to Shi Jin to present her arguments, second speaker arguments for the motion.
Good afternoon, everyone. It's Shi Jin here. Well, I don't think Matt and I are particularly surprised by the survey results because I don't think anybody would disagree that party-appointed experts are the more preferred approach for both practitioners and experts currently. A 2012 International Arbitration Survey reported 90% of expert witnesses appointed by the parties. So Matt and I have done our own survey as well, and between the both of us, we've only had tribunal appointed experts twice, Matt twice, and myself 0 times. Well, I don't know how many more years of experience Matt has in arbitration, but I guess we probably shouldn't go into that right now. Yeah, but at the same time, it's clearly recognized that there are faults in the current practice. I think James himself has conceded that in his first point. In the same survey, at least less than half of the respondents found expert witnesses more effective when they are appointed by parties. I mean, this clearly shows that the current practice is unsatisfactory, and this is why it has to change. It is our submission that the best way forward is for tribunal-appointed experts to replace the current practice of party-appointed experts. And I will now touch on a few reasons why. So first of all, there is a stronger regulatory framework for tribunal-appointed experts. For example, the Section 37 of the 1996 Arbitration Act. This expressly sets out the tribunal's power to appoint experts. The model law also has a similar provision in Article 26. Many sets of arbitration rules also contain provisions setting out a procedural framework for tribunal-appointed experts. An example is Article 21 of the LCIA rules and Article 25 of the HKIC rules. There are also similar provisions in the SIAC rules and the UNCITRAL rules. However, these provisions are rarely used by practitioners. They're sort of like my legal textbooks. We know that lawyers just go to Google first and That's probably me. On the other hand, both national laws and arbitration rules are silent as to the appropriate procedural framework for party-appointed experts. A number of rules, like the ICC rules and the SIAC rules, implicitly accept that parties have the power to appoint expert witnesses, but do not go any further to set out what the procedural framework should be. This leads me to my second point. The lack of a procedural framework for party-appointed experts exacerbates the perennial problem plaguing party-appointed experts, that it's difficult to maintain objectivity and independence. This is a problem that has been highlighted for decades, but yet nothing has changed. In Lord Wolf's 1996 report that Matt mentioned earlier, he stated, "The present system has the effect of exaggerating the adversarial role of experts, and this helps neither the court nor the parties." So we fast forward 2.5 decades to today, and unfortunately, the same concerns remain. It's particularly concerning that in a 2019 survey of expert witnesses, 41% of the respondents indicated that in the preceding 12 months, they had come across an expert witness who they considered to be a hired gun. 25% of the respondents also reported that they had been felt pressurized to change their report in a way that damaged their impartiality. It may be argued that there are soft law instruments like the IBA Rules of Evidence or the CIArb Protocol, which provide that party-appointed experts have to comply with requirements of independence. But these are merely guidelines. As Professor Doug Jones stated, it is unclear whether these codes of conduct actually reduce partiality and bias in experts. Neither the rules nor the CIArb Protocol themselves explain how an expert can truly be independent and not merely show independence. This limits the existing guidelines from being anything more than a mere statement of principle. I would argue that the root cause of the problem that party-appointed experts face in maintaining objectivity and independence is the very fact that the expert is appointed by the party and its lawyers. So this means that the expert's retainer is with the party and his or her fees are being paid by the party. Arguably, the fact that the expert is paid for by the party would either consciously or subconsciously result in the expert framing their evidence to support the party employing them. It must also be conceded that full-time experts have a natural inclination to being retained in future matters by instructing lawyers or parties, and would want to make sure that their instructing party is satisfied with their opinion and evidence. In addition, the fact that an expert takes its instructions from a party will mean that the expert would invariably understand and familiarize themselves with the case from a certain point of view. Again, consciously or subconsciously, this may sway the expert towards adopting a particular position or direction with their evidence. The best way, and we would submit the only way to deal with this problem, is to change the entire approach to expert evidence from being party appointed to tribunal appointed. Once this approach is changed to party-appointed experts, there will be no more contractual relationship with the parties. There will be less contact between the expert and the party as the expert takes its instructions from the tribunal. This will allow the expert to have more capacity to remain impartial and objective. Another problem with the current practice of party-appointed experts is when you have ships passing through the night. What I mean by this is when experts rely on conflicting methodology or facts, which they commonly do as a natural consequence of obtaining their instructions from parties adverse to each other. This results in diverging opinions which provide no assistance to the tribunal. A report released by the LCIA in 2018 on expert witnesses highlighted this as one of the most significant difficulties with party-appointed experts. I'm pretty sure that all of us have experienced this in practice. And it may be argued that the solution to this problem is the procedure of a joint meeting and a joint statement between experts, which is typically used in arbitration. The same LCIA report stated that this procedure would not resolve fundamental incompatibilities, not in the least, as they are typically the result of instructions from the lawyers involved in the case. And I think this happens quite commonly as well, that experts can reach a great deal of agreement at the joint meeting, but somehow when it comes to the joint statement and the lawyers get involved, very little is actually recorded as agreed. The tribunal appointed expert will resolve this problem because the expert will receive one set of instructions from the tribunal that it will base its opinion on. So finally, my last point is that tribunal appointed experts would better ensure fairness to proceedings. There is commonly an arms race when it comes to adducing expert evidence in arbitration. For example, if a party wishes to adduce expert evidence on an issue that the other party did not think is necessary, the other party would more likely than not instruct an expert on the same issue. I think this in particular resonates with me a lot because I'm a person that always suffers from FOMO. If someone else has something, and usually it's a new bag or a pair of shoes, I automatically want the same thing, even though I never thought that I would need it in the first place. So apart from this, increasing time and cost in arbitration and reducing efficiency, another problem here arises when parties have unequal resources and one has some constraints to appoint experts. A tribunal-appointed expert in this regard will help level the playing field and ensure fairness between parties. Appointment by the tribunal directly also means that the tribunal retains supervisory responsibility over the expert's conduct and performance. And this encourages the focus of expert evidence to assist the tribunal in delivering fair and efficient outcomes, which is, as Matt mentioned, the object of an expert in the first place. So thanks very much.
Thanks, Shijin, and thanks for the plug for the CIArb protocol. Always appreciated. Samuel, the floor is yours.
Thank you very much, Madam Moderator, esteemed panel of judges, speakers for the proposition, James. Ladies and gentlemen, as introduced, my name is Samuel, and I'm very glad to be bringing up the rear as a second speaker for the opposition in what is already a very heated debate on a very hot topic. And before I plunge into my discussion on the motion of the day, which James has so convincingly argued against already, I just wanted to inform everybody, just as a report from the ground, that this debate today is being watched very closely by certain industry groups. In particular, slide comes on, by the International Federation of Hot Tub Manufacturers. I'm told that their business case, their business projections, just a little bit on how you guys vote today. At the same time, in doing my research, I have discovered that there are some people who feel really strongly about this topic. They're almost like hot tub fanatics. And one of them have even started a change.org petition on the subject that we're discussing today. It's a very catchy slogan. It's started by Jim N. Not sure. Slide off. So, ladies and gentlemen, just aside. So now that I've given you the significance of today's motion from the grassroots level, this is a democratic process today after all. Allow me to then give you 3 points to consider in support of our case. That is, parties should be allowed to appoint their own experts, and tribunal experts are not the way to go. I propose to make 3 quick points. And they're phrased as such, right? So that having only tribunal appointed experts is not the way to go. One, for the sake of the truth. Let's not forget that that's an important thing. Number 2, for the sake of the parties. And number 3, for the sake of members of CIArb, of the arbitrators. So let's dive right in. First, tribunal appointed experts are not the only way to go, and that's for the sake of the truth. And you've already heard from James that just the psychological effect of having an expert face, or knowing that the expert has to face a worthy opponent in the course of the expert reports and in the course of the hearing is good enough and powerful enough to ensure that that expert, that party appointed expert, is careful, diligent, circumspect. And that in itself is a great illustration of the working out of John Stuart Mill's theory. And that theory, of course, is the marketplace of ideas. You may remember from your days in your jurisprudence classes in school that Mill's theory, published in 1859, was simply that no body alone knows the entire truth, and no one idea alone embodies the whole truth. And so the best way for the truth to surface is for competition, contestation, a free market of ideas to develop such that you are able, or people are able, to separate falsehoods from truth, right? So now the party appointed expert system, in a rather specific way, is a practical working model. And we know experts love their models. The Excel spreadsheet kind, not the hot tub kind, sorry. But experts love their models, and it's a great working out of this exact principle, this exact theory of John Stuart Mill, right? The marketplace of ideas. So this process, which includes, of course, expert reports which disagree with each other, reply experts reports which further disagree with each other, and then hard-hitting, ferocious cross-examination at the hearing, it's all targeted to simulate the marketplace of ideas with that one goal in mind, so that by the time we reach the witness conference, by the time we reach the hot tub, the truth had slowly bubbled up to the surface, like a jacuzzi stream, I suppose. And much like the adversarial system that we common lawyers love so much, the skirmishes and the clashes, they're all targeted so that the tribunal can get to the truth. And if you lose the tribunal, the party-appointed expert system, you lose a bit and you end up perhaps a little bit further from the truth than we ought to be. Second point, having only tribunal-appointed experts is not the way to go for the sake of the parties. And again, James has convincingly argued, cogently argued, that costs is the savings of costs or reductions in costs is really a little bit of an illusion. It won't happen because invariably parties will appoint shadow experts. But I like to approach this point from another angle, and that is the wonderful thing that, again, us disputes lawyers love, the wonderful thing of litigation privilege. And my suggestion to you is that if you remove the use of party-appointed experts, you reduce the benefit that parties have of this, again, wonderful principle of litigation privilege. Litigation privilege, what do I mean? It is a thing of significant value to a party to be able to engage in an honest, frank, and open discussion with a qualified, a respected, and experienced expert about the full what's and all, good and bad of the merits of the client's case. And it is also of significant value for that expert to be the one addressing the tribunal. It's not controversial that if, as the proposition has suggested, if you only have a tribunal-appointed expert, what are the parties going to do? They're going to filter, you're going to curate, you're going to sugarcoat every single thing, that is, every single fact, every single thing that's presented to that tribunal expert. And then we expect this tribunal-appointed expert to then assist the tribunal with only this sort of filtered version, a watered-down version of the facts. That's hardly satisfactory. So, I mean, there is, of course, merit to the idea of neutrality, but what we are suggesting is that it's too big of a trade-off. By having only a tribunal-appointed expert, the trade-off of losing the value of having an open, honest, and frank discussion with the expert who is going to address the tribunal. It's a price that's too big to pay. In fact, if you read the publicity for today's debate, there's mention of the case, the wonderfully anonymized case of A company versus X, Y, and Z, in which the English High Court expressly held and established the principle that experts do hold a fiduciary duty to the clients alongside the expert's duty to provide an independent analysis or an independent opinion on the expert issues in dispute. Those two duties do not conflict with each other, and therein, I think, lends support to this idea that it is within the confines of the shall we say, the warm blanket of litigation privilege, that a client is able to speak freely with its expert and then have that expert independently and fairly provide an accurate professional opinion on the case that is valuable, and it's not worth giving up just to have a neutral expert appointed. Now, my third and final point on this topic is that having only tribunal experts is not the way to go for the sake of you, the members of CIArb, for arbitrators. It's hardly a secret, but I think, and I'll be very careful, that whenever it can be done within the parameters of justice and procedural fairness, it is useful, I put it no higher than that, it is useful for arbitrators to delay this appointment. In particular, delay disappointing one party. And that is to say, because having the buy-in of all parties improves the efficiency of the arbitral process. It helps to keep procedural deadlines, submission deadlines, even payment of deposits. And where a tribunal has to disappoint a party early in the proceedings, as the members of the proposition is suggesting, there's a risk that they lose buy-in. And of course, that risk, again, is one that will become obvious, particularly when you talk about the very, very specific and often heavily contested points of how to appoint a tribunal appointed expert. There will be things like the framing of the specific terms of reference and the issues and the scope of the issues to be opined on, the profile and the qualification of the expert concerned, and even the identity, the expert who will be appointed. These are things that parties often feel very strongly about. And if you have to, in an early stage of the proceedings, disappoint the party, you may risk the buy-in of that party in the arbitral process. And that's not helpful for arbitrators as sort of on a tactical basis or from a technique basis. So those are my 3 points as to why the motion should be rejected. But ladies and gentlemen, at the end of the day, I think the fact that everyone in this room understands that witness conferencing is synonymous with hot tubbing proves the success of witness conferencing as a technique or as a hearing method. And to have a witness, to have a witness conference, I'll end here. To have a witness conference, you need more than one expert. And can I bring the slide back up? As we know, hot tubs for one, they ain't no fun. Thank you very much. Yeah.
I'll let you have that extra time without deleting time for rebuttals because your slide was so good.
Much appreciated. Much appreciated.
We have a few questions so far online. Those of you online, please do post more questions and I will sift through them. We've got a few comments as well, but yes, I'm encouraging the over 400 people I think we have online to submit some questions. Those of you in the audience, please think of some questions. You'll be able to pose those questions live. And what we're going to do first is move to our judges for questions. If we could have a microphone to the judges, I'm going to give this microphone to Matt.
Hi, good evening, everyone. Not evening, actually late afternoon. Thank you for that really enlightening and engaging submissions that we have heard from the debaters. I think both sides have brought up very, very interesting points, and I think issues that we face with experts in arbitration and how we deal with issues that arise out of it. Now, the one point actually I like to pose, or one question I like to pose to James and to Samuel is this. You know, as Matthew said, when you have an expert witness, usually you deal with technical matters or matters which the tribunal do not have expertise in, right? So essentially, in that particular field, the tribunal would be laypersons without the specialized knowledge. And here you present with two parties, you present two or more experts coming out with their views on the very technical matters. And sometimes you can have two experts presenting very opposing views that do not mean have no overlap, right? And being a layperson, the arbitrator being a layperson or tribunal being a layperson, how do they decide? How do they decide whose view is actually more reasonable, more acceptable, you know? And how would a party appointed experts help in the decision making in that scenario, you know? And I think in a situation like this, that I think judges and arbitrators have cried out for help and say, wouldn't the right way to go really is to get someone that we trust and we can give instruction to decide on the particular technical issues, so that we don't have to make a decision on an all or nothing basis without the expertise or without the capability of deciding who is more right and who is more wrong. That would be my question.
I'll take a whack at it. Thanks, Yilam, for the question. So if I understand you correctly, how should tribunals approach party-appointed experts that have given hugely diverging opinions, no overlap, no common points of agreement? And I suppose 2 points. One is there is the solution of a partial award, where the tribunal makes certain findings on the relevant facts and maybe certain preliminary statements or decisions that they relate to where the disagreement is, and then sends it back to the parties. Parties don't like it. It extends time, it extends cost, but that may be a fair way to do it, where you force the parties, the experts, to narrow the issues because you've already set the ground rules or the parameters of the expert inquiry. That's one potential solution, I suppose. And the other one is, I mean, tribunals, arbitrators have cried out for help, but they're crying out for help to do the job that they were appointed to do. The job of an arbitrator is to wrestle with tough technical disputes, all of the disputes, and their job is to wrestle with it. So in a sense, all the best to us.
I'm not quite sure why the mic has been handed to me, but I think of a question. Maybe to be fair, for Matthew and Shijin, and I asked this based on what Yi Leong tells me, because he remembers life before hot tubbing. And you know, probably too young to remember that. Oh yes, definitely. And the question is this: has hot tubbing gone some way to reducing the concern about party-appointed experts being less independent and less impartial in their presentation of the evidence? And do we then need to go to the extent of tribunal-appointed experts?
I think leaving aside whatever campaign may be being mounted by the Institute of Hot Tub Manufacturers, I think there are 2 points about hot tub, and they're really rhetorical answers. Firstly, how prevalent really is it? You see it in many procedural timetables, provision for hot tubbing, and then you get to that delicate moment on the 4th afternoon of the hearing where you say to the tribunal, well, would you be now cross hot tubbing or conferencing, to use the more technical term, more polite term, the experts tomorrow? And they look along the bench to each other and then they say, I don't think it's in fact necessary. So in my experience, that happens a lot. Secondly, if they say, yes, they will have some questions, very often they don't get to the heart of the matter. And the process will be very short compared to the 1 or 2 days of expert evidence that you have had in the cross-examination. So yes, if there was a tradition, a really well-established tradition of proper rigorous hot tubbing, it might go some way, I only say some way, towards responding to the proposition, but I don't see it.
To be fair, then I'll give one question to each side. Okay, maybe I'll start with the opposition first. I think there was the point made that there might be lack of competition, right? If you're just going to have one expert appointed by the tribunal. Would you not say that in a scenario where there's just one appointed expert, you're going to have, as you say, the shadow experts? And if an esteemed shadow expert like you, James, couldn't, with esteemed counsel like Samuel, then be your mouthpiece to then generate that competition?
Yes, I think that could happen. But then you're moving towards a situation where you essentially got a fourth, second tribunal member, because you're back with something quite close to party appointed experts, probably worse than party appointed experts if the arguments are coming through council and being pulled even further in obstructing parties' direction. And you've got an expert who's sitting in the middle, who's basically deciding. So I'm not against experts deciding on except good if experts were involved in decision making more often, but that's not the situation we're typically talking about. That's not what parties are typically choosing. Arbitration.
All right, going on to the other side. The point about partiality, right? The risk of partiality. Would you not say that with the adversarial process, you could tease out what's lacking or what's questionable about the report that you may consider partial?
You may try to tease out the partiality, I think is the answer to that. But how easy is that to do? It also becomes quite, it becomes a process in itself. You know, we're all used to interrogating or considering how we interrogate the integrity of arbitrators we appoint. We're all worried about whether they've been appointed by another office of that law firm in a case in South America 4 years ago and it hasn't been disclosed and we don't know about it. Once you get this sort of corporatization of experts, which is essentially the problem that, at least on our side of the table, we're arguing about, then of course you open up this process and you open up the need to go on a train of inquiry to interrogate the integrity of the expert. If the expert has been appointed from an open list, the tribunal expert has been appointed from an open list, which of course the parties can contribute to, and they do contribute to, but ultimately it's a decision for the arbitrators, then you don't, that process may exist to an extent, but it doesn't become nearly as burdensome.
Okay, I'm not sure if this is working, but hopefully you can all hear me. If you are in our in-person audience and you have a question, please could you put your hand up? We do have microphones stationed here, but actually we can bring the microphone to you, because while you are thinking of your question and putting your hand up, I'm actually going to ask our team for the motion two questions, which I'll put together in one, which I think you've sort of answered, Matt. And the question is this: how do you ensure the quality of the expert when you're instructing a single joint expert? And how can you mitigate the risk of challenge to the arbitrators or the award of appointing the wrong expert in the eyes of at least one of the parties?
Well, I think it's Article 26 of the SIAC rules obviously sets out 2 or 3 obvious propositions, sensible, common sense propositions. One is that you have to consult, the tribunal, have to consult with the parties before you go down the route, to give the parties an opportunity to comment on whether it's desirable, the scope of instructions, and who the expert should be. Probably other things too, but certainly those 3 things. And as part of that, of course, you start to get a list of experts coming forward, and of course you get their CVs. You can even ask them questions if you doubt their expertise. And then as a second part of that, you start to settle their mandate. So you obviously, if you're being a sensible tribunal, fully complying with Article 26, you ask the parties to comment and try and help you delineate the mandate of the expert. I think, of course, there were always challenges, good and bad, will crop up from time to time, but those two steps, I think, go quite some way towards dealing with the point that's a sensible point, I mean, sensibly raised, but I think those would be the answers.
Essentially, you consult.
You consult, and you have to consult.
Thank you. We seem to have a very shy in-person audience. We don't have anyone with their hand up. Oh, we do. Wonderful.
My name is John Tan. My question is for the proposition. In a situation where a tribunal takes control of the expert early on, gives its terms of reference and instructions to both sets of experts, define the issues jointly with the parties, and then gives instruction to the experts that they produce first a joint report agreeing on things that they've, on issues that they've agreed on, and only produce the individual report after they produce the joint expert report on matters where they disagree. That would, in a way, reduce the numbers of points where the expert differs. And then when the joint report are in, together with the individual expert reports, for the tribunal to then have another meeting with the expert together with counsel to narrow further issues where the experts are in disagreement. And that would it not avoid the scenario of ships passing in the night, avoids issues where the parties are addressing issues where they are not crossing swords. And in that way, would you still say that the parties should not be permitted or encouraged to have their own expert? Would such procedures assist in narrowing issues and making the arbitration more efficient and cost effective? Thank you.
I think that technically and in theory that yes, that could be a way, but I think in practice that is probably very difficult to achieve because at the end of the day, the parties are still the ones instructing the experts. It would go in with a certain set of instructions. The first joint report would probably be meaningless because the experts would just be instructed not to agree on anything. And then in the end, it would probably just make the entire process longer, create more efficiency. So in theory, yes, but we would say, I think the essence of the relationship between the party and the expert for party appointed experts just make it very difficult for this process to actually be achieved.
Thank you. So we've got one question, I think, from the floor. We're going a little bit beyond the Q&A segment because interesting questions. So Alistair, please.
Thank you, Sabna. Thank you, everybody, for an excellent debate so far. I have a comment which leads to a question for each of you. And my comment is that I think you are debating different things because Matt and Shijin, I think you're rightly identifying a problem with the way that expert evidence is handled in arbitration at the moment, and few people would disagree with that, and you've proposed a solution. And James and Samuel, you're looking at the practicalities of this, and you're saying, well, that's not a practical solution here. So we're talking theory on one side and practicality on the other, and that leads to James's excellent analogy of an egg whisk trying to crack a nut. So for Matt and Shijin, well, maybe I'll start with James and Samuel. If you don't think this is the solution, what is the solution? It's all very well to knock it down, but let's hear something positive. And for Matt and Shijin, I would be interested to hear your response to the two very valid concerns that James raised as to shadow experts and as to the quality of the expertise if there's only one expert on the stage. Thank you.
Thanks, Alistair. I'll go first as the question came to us first. So I also agree that there are problems with the way experts use the arbitrage. And I long thought that there are process changes that could be made that could move. There are process changes that could be made along the lines that Johnny Tan, I think, was suggesting in his question of getting experts together earlier and getting counsel less involved in the process. And I think that then you would get less of the wide divergences, less of the problems that we all see sometimes in cases, because it's true that experts are human beings. It's true that when you spend all your time with your instructing counsel and your party and you hear their side of the story, and that does have an effect, whether you want it to or not. It's true that instructions are slanted, of course, to push experts one way or another. So I think earlier meetings of experts and some sort of regulation of party and council interaction with experts is the way to go. I don't have the concrete, detailed solution. I think in some jurisdictions there's quite heavy policing of interactions between, and the assumption of without privilege communication between experts and counsel isn't there in some jurisdictions, I believe. That may help, although it may just push everything onto long phone calls rather than long emails. So maybe it doesn't help. So I think the solutions are to be found in process fixes in how experts are used, and they are potentially to be found in ways, and you will all know better than me what those ways might be, of getting tribunals to engage earlier with issues so that they can give a steer to the parties earlier on in the case. Although knowing that that's of course very difficult, because until the evidence is out and so forth, it's premature to do that.
And the final question for this Q&A segment is, Matt, you had mentioned being involved in 2 cases where there had been a tribunal appointed expert. Could you please comment on the outcome efficiency of how that worked? And also, was there just one tribunal appointed expert, or was there a combination of tribunal appointed expert and 2 party appointed experts? And I think that's just interesting for all of us as a learning opportunity.
Never have I seen anything so. The more honest answer is that in the first case, it was quite good, because the tribunal, the party said, we want memorials. The tribunal said, no, you can't have memorials. We want a short, page-limited statement of claim and statement of response or statement of defense, and then we want you back here in 3 months' time. And so the tribunal really did take the bull by the horns. And then the tribunal said, well, it's clear that there needs to be expert evidence in this area on these issues. And frankly, the parties worked together on the brief. So the expert answers to the tribunally mandated questions were actually answers that the parties, in some respects, could actually agree with. So there didn't need to be an extensive process. Second time round, without going into it, was less desirable.
Thank you. With that, we'll move in to final rebuttal arguments. And so we will hear from the, again, probably I think from Matt for the motion. You've got 5 minutes.
James said that he had 3 points. He said that his second point was devastating. He didn't tell us what his second point was. He should have done so because the other two didn't amount to very much. The first was what Alistair then summarised as the shadowing point, or as James put it clearly, 2 experts becomes 3. Now, that is with respect a straw man, as people would say, because just because you have a tribunal appointed expert, it doesn't necessarily mean that the parties need to go through the full rigmarole, the full regalia of instructing their own expert. You have the tribunal's answers to the tribunal experts' answers to the 15 questions that the tribunal has put to them. You obviously need to take them away. You obviously need to consider whether you agree with them. You may well need the assistance of an external expert to decide to the extent to which you agree with those answers, but that is often less extensive and less costly, less time consuming than the full process of producing your own report, and certainly producing your own report ab initio before you know really what the other side is saying, or before the issues have really been joined in debate. Secondly, in that shadowing point, and in my first case that I was referring to, this happened, sometimes the cross-checking exercise, so I would prefer to say it's a cross-checking exercise rather than a shadowing exercise, can be done by your own clients. So if, for example, it is a question of assessing technical expert, for example, on the assessment of reserves in an oil or gas block, if you're acting for an oil and gas company, they will have people who know that block and know that area and will be able to look quite quickly at the extent to which they agree or disagree with what's being said and decide, you know, whether or to what extent you then need to tool up with an external expert. James's second point, as I say, was said to be devastating, but was unfortunately concealed. The third point was a point that I found hard to follow, something to do with Thierry Henry doing keepy uppies in the back garden, or Serena Williams hitting balls against a wall. With respect, that doesn't appear to have direct relevance to the issues before us. Now then, to compound James's confusion, he then said Samuel had 2 points. Samuel may have been worried by what he heard, because Samuel actually had 3 points. The first was a point about truth and John Stuart Mill, and that essentially it appeared to be the more experts one has, the closer to the truth that one would get. That, if you've, like me in recent times, been involved in a situation where expert 1 produces 260 pages, expert 2 at the same time produces his or her own 300 pages, and then they then join battle in replies with 400 plays 500 pages, is with respect very far off from the mark. The second point was a clever point, but again is also wide of the mark. Samuel's point was that the parties lose, I think you said, Samuel, the warm blanket of litigation privilege. Now, the answer to that is the extent to which that privilege exists or does not exist is not affected by one's interaction with the tribunal expert. Of course, one's interactions with the tribunal expert are not subject to privilege because they have crossed the table, they have crossed the line. But of course, anything you do privately behind the curtain to consider the technical, the accounting evidence, or whatever it may be, will of course be subject to privilege in the usual way. If it was otherwise privileged, it would still be privileged. The fact of a tribunal expert appearing on the scene does not affect that. And the third was a surprising point, that a tribunal expert makes it difficult, you said, for a tribunal to delay disappointing a party. Now, that is not the role of a tribunal. Tribunals are there to render clear and prompt decisions. As you later said, more honestly and more correctly, their job is, and I quote you, to wrestle with the tough disputes. That is their job. Their job is not to delay disappointing a party. Thank you.
Thank you. And now to our final speaker of this debate. James will be closing the arguments for those against this motion.
Thank you, Sam. We plan actually to share our time.
Oh,
That's
fine.
okay. Ladies and gentlemen, I warned you at the beginning of my comments about the inequality of arms, and we've just seen a demonstration of those dark arts of play. Simba over here mauling me with his ad hominem attacks, mischaracterizations of my arguments, and not grappling with the true underlying points. The tribunal appointed experts increase cost, dull the quality of the output of the experts. I think those points are clear. And I think Matt hasn't really engaged, certainly with the second one, which he attempted to ridicule rather than respond to. The first point about cost, Matt hypothesized a process whereby the parties do not think about the expert issues before the tribunal appointed expert until the tribunal appointed expert has issued her or his report. And that's not, I think, how things would really go. I think the parties would be very anxious about the expert issues, which are often fundamental to liability or the amount of money that will change hands at the end of a case. I'm speculating here, but I would imagine that the parties would be wanting, and the tribunals would let parties make submissions on expert issues before the tribunal appointed expert issues their report, so that the parties can be sure that their points are getting across. Otherwise, there risks of randomness in the process. The expert, unguided by the parties to the issues, may miss important points, important arguments or perspectives. So I think perhaps if the parties are ignoring expert issues until after the tribunal appointed expert has issued their report, that there may indeed be a cost saving, but with a severe trade-off on the quality of the output and the outcome. I think if one has a process that has parties engaging early in the expert issues, as one would expect, that you're back to my point that you've got three experts, each addressing a broader scope of issues than the two experts would have been in a party-appointed situation. I also, in fact, gave most of my rebuttal points in response to Alistair's question, which is just as well because we're running out of time, and I promised Sam a couple of minutes to wrap up.
Sure, just very quickly. I mean, not to be splitting hairs, but I did say that there is value for the expert who is within this warm blanket of litigation privilege to be the one addressing the tribunal, right? Putting on its hat of independence and having its professional opinion, having already heard what his or her instructing party has told him within that warm blanket. And I think that's why we will lose invariably if we go with only tribunal appointed experts. Point number 3 was a carefully worded one. I won't go any further than that. But it's a technique that often junior arbitrators have to be mindful of, because lower value disputes, parties tend to be careful about costs and whether or not they want to carry on funding a dispute that may not go its way. And so for smaller value cases especially, I think keeping buy-in is useful within the parameters of justice and procedural fairness, if possible. And if I could just address Alice's question, or attempt to address Alice's question, I suppose throwing it back to the members of CIArb, one potential solution was, in fact, already addressed. Johnny had mentioned it. I touched on it. It's braver tribunals that are empowered and are not, don't live in fear of the set aside, and go ahead and grasp things by the nettle to require experts to the conference early, to come up with a list of agreed issues and list of disagreed or list issues on which they disagree, and then maybe even at the cost of time, I understand, issue partial awards that say, look, an economic analysis doesn't make sense. We are going with DCF. Now you guys come back with numbers. I mean, these are things that tribunals can do. But obviously sometimes risking disappointing both parties, which is fine in terms of timelines. But maybe that's one solution.
Thank you very much, Samuel. I was a bit disappointed not to see your hot tub slide again. So that is it. Thank you very much to our debaters for their great sportsmanship. Well played. You've heard all the arguments now, audience. While the judges quietly deliberate, we're going to have our second audience poll. So again, you can see the QR code on the screen. And let's see if the dial has moved. Wow, this is very close. Since I can't influence anyone now, I have to say, Samuel, I wasn't sure your point about experts being able to address the tribunal, having been able to discuss the case under the cloak of litigation privilege. I wasn't sure if that was a point for them. Wow, this is a very interesting outcome. The pendulum has swung. We'll just wait a moment for the... But if somebody wants to check on the judges, maybe give them a gentle nudge. They're taking the deliberations very seriously, clearly. And they are returning. Do we have a microphone for our judges, please, for them to be able to announce the decision?
Hello, can you hear me?
Yes.
Okay. First of all, just let me say that I think both parties did very well. I think the proponent of the proposition has a much tougher job as far as we are concerned, because frankly, the way that the proposition has been drafted, it is not an easy one to advance because of the narrow nature of the proposition. But I think we all agree with what Alastair has said, that there is a lot of problems with the current way in which expert evidence are presented. And they have very successfully brought up those issues and show us why we need to do something about it, why they need to change, and why we cannot carry on life as usual. I think Johnny has come out with some of the proposals that we can address the issues. I think personally, I have come across techniques used by arbitrators. I think early engagement is definitely a must. A settlement of a list of expert issues before parties are allowed to introduce experts. Tribunals leave it must be granted before experts are allowed. Disciplines must be determined by the experts or by the tribunal, and number of experts also must be determined by tribunal. Those are all techniques that we can use, right? Well, I think James and Samuel has pointed out some very obvious disadvantage in having a situation where only the experts appoint only the tribunal experts appoint the experts, and parties are not allowed to appoint the experts. The cost is definitely one issue. And for those of us who practice in Singapore, that is an issue that we have been grappling with, because our rules of court have also been amended, so that I think the default is that only the court can appoint experts, and parties need leave of court before they can appoint their own experts. And that is one issue that we have been brought up, cost. Quality of report, again, is the other. But on the overall, my personal view, my two fellow judges will come up and say what their view is. My personal view, I think, is that the Matthew and Xi Jing has done a much better job in terms of pushing their case. Okay, but I'm not going to declare a winner, because it is almost, I think, impossible to win on a proposition that they have. Okay, that's my view. Thanks.
Thank you.
I'm going to be much briefer and I'm going to try and do it standing up from here. Agree largely with everything Eagle has said, surprisingly. I think I'd be really grateful for the 4 speakers who really care about what we do and about how we can improve the process. I think if there's one thing we've learned from this evening is that what certainly I came into this thinking might be a much flogged horse has really been jumping in, been given a whole new lease of life. And these are issues that we do have to consider as this process we care about develops. For my part, and I'm extremely grateful for the clarity and the thoughtfulness that has gone into it, and the humor and as well. Unlike Eagle, I'm not going to take a position on sides because that's Madam Chairperson's privilege.
Very diplomatic judges we have so far. Let's see how our presiding judge.
Very gentlemanly
Pass the vote.
co-judges I have as well. Yeah. They sort of decided a few weeks ago between themselves that I would be head judge. But it's all democratic. As Yang has said, I think the proposition, the motion in itself, it's skewed in some way. But we're all here to have fun, and fun we had indeed today, right? And for us practitioners, usually we're on the side of the bar, and we don't usually get to decide. So today we had that opportunity. It's a nice change. We came here to be to have some diversion, and diverted we were today, right? Definitely from the proposition side, as Yong has mentioned, it is tough, but they did a great job, pushing that case, what was difficult. And certainly they got a good fight from the opposition as well. Slides included. Yeah. So with all that, taking all into account, really, I think at the end of the day, we feel that there shouldn't be a real winner at the end of the day. You're all winners. You're all in this gladiator ring. Whether you walk out of this hobbling or otherwise, you did a great job, and you can be proud of yourselves. Yeah. So we don't understand between you and your drinks, after which perhaps we could get that deep, dark, devastating secret of all of James. So I'd say a round of applause to both sides. Yeah.
The most diplomatic judges we have ever had. Thank you so much, judges, for your attention. Thank you for your questions, and thank you for your diplomacy. Thank you so much, the debaters. I know that Sue-Ann, on behalf of SIAC, will give her own vote of thanks. But I just want to give my personal thanks on behalf of the branch. Both sides clearly prepared really well. You made it fun and you made it engaging, and it was a real pleasure to be part of. So thank you very much to our debaters again. And can I also just say thank you to the CIArb Secretariat and the SIAC BD team who have worked very closely together, and with Maxwell Chambers, who've been extremely helpful as well to be able to put on this evening for us. We couldn't have done it without them, and they've really done an excellent job. So thank you. And I think Sue-Ann now will say a few words in closing.
Thank you, Sapna. Thank you to all debaters for the exciting debate, and thank you to our judges. Once again, thank you all for joining us in person, and the online participants for being here with us today. We would also like to thank our sponsors for generously sponsoring this event. For those who are here in person, please join us for the networking drinks right after this at the foyer outside this room. Thank you once again, and we hope to see you soon again. Have a lovely evening.